Hello and welcome to this video about vicarious liability, which you'll find in paper 2 of the AQA A-Level Law exam. So in the exam, vicarious liability applies where an employee has committed a tort, such as negligence, including causing psychiatric harm, or often where there is a negligent misstatement. It's not a tort on its own, it imposes secondary liability, and this means that you don't claim vicarious liability, instead an employer is found to be vicariously liable. So it's a method of making an employer liable to pay damages instead of the employee. It is strict liability, so there are no defences available to an employer, so this shows that it is not linked to fault on the part of the employer. It's said that it's been on the move in recent years, which means that there have been some important cases, but now the law seems to be a little bit more settled. So let's have a look at the three parties in vicarious liability. You will always have three. Firstly, the victim of the negligence. So here, let's assume that the victim has been hit, her car's been hit by an employee of the post office, and this postal worker has crashed into her car, and so she is going to be suing that employee. Now it is quite likely that the employee would not have the money available, and if we ignore the position on insurance for a minute, we can see that it might be much more useful for her if she can also sue the employer, because they, as the post office themselves, are much more likely to have the money to pay. So you can see that in this case, although it's the employee that has been negligent with his negligent driving, it's the post office, the employer, that is going to end up paying, and that is how vicarious liability works. So if you look at Lord Sumption's quote here, you can see that vicarious liability covers a very broad range of situations and is very wide indeed. It covers all acts done within the course of the agent's employment, however humble and remote he may be from the decision-making process. And even if his acts are unknown to the principal, this means the principal here means the employer. So even if what the employee does is not known about by the employer, it's not authorised by the employer, it's adverse to the employer's interests, or even contrary to the employer's express instructions, even if the acts are criminal themselves, then the employer will still be vicariously liable. So there are policy reasons why this is the case, and these include the fact that it spreads financial loss, and that the employer has the resources probably to pay the compensation and may also have insurance. The employer has control of the employees and benefits from their work, so it seems sensible that they also have to take the risk of what the employee does. And as they are responsible for hiring and training staff, this should make them more careful when they choose who they're going to hire and choose how they train them, if they know they're going to be responsible for their negligent actions. If the employer is creating the risk of the tort occurring by, for example, letting an employee drive a very large lorry, then they should be liable for the results. And this is the case even if the employee is misusing their position. So how to spot vicarious liability in an exam? You need to look for another name of someone who seems to employ the person who has committed a tort. And the person that's committed a tort is sometimes called the tortfeasor. It's often going to arise in relation to negligent misstatement, which is the case in the scenario that we're going to have a look at. So see if you can spot it in this scenario. So you can pause that for a moment and have a look at it and see what you think. So if you look at the scenario now, you will see that it doesn't mention vicarious liability at all, or indeed negligent misstatement for that matter, in the question. The only clue is in the question it asks you whether Harry has rights and remedies against Jim, who's the person who gave the negligent misstatement, and against Index Services. So there is your clue. Oh, as an employer in this scenario, so I need to consider vicarious liability. And the part highlighted on the second row is relevant here because it says George engaged Index Services to advise him on the suitability of his house for the loft conversion. And then they, Index Services, send Jim, the surveyor, who they usually use for the purpose. So those are the clues that suggest to you that you're going to need negligent misstatement first and then vicarious liability. So let's have a look at what you actually need to consider when you're deciding if an employer is vicariously liable. There are two things that you need to show. Firstly, that the person that committed the tort was an employee, and secondly, that there was a sufficiently close connection between the employee's field of activities and the wrongful conduct. So it's just a two-stage process. Let's start with the first stage, which is the meaning of employee. Now, traditionally, the courts use tests like control. Did the employer have control over the employee? Or they used an integration test. Was the employee integrated into the employer's business? But on their own, it's felt that they weren't the greatest of help in deciding if someone is employed or if they are an independent contractor. And bear in mind that an independent contractor is sometimes called someone who is self-employed. They use words are used interchangeably. So having decided that those tests were no good, the courts tend to use the economic reality test established in Ready Mixed Concrete and Minister of Pensions. And this established three conditions for an employment relationship. The first is that the employee agrees to provide work in return for a wage. Secondly, the employee accepts that the work is subject to the employer's control. And thirdly, that all other factors are consistent with the existence of an employment contract. And bear in mind here that it makes no difference if you are working part-time or full-time. You simply still apply these factors. So if you're applying this in the exam, you have to be sure to say which way the factor points. Does it point towards an employee or does it point towards an independent contractor? So for example, when you are considering whether the employee agrees to provide work in return for a wage, everyone will be being paid for a job. The question is how they're being paid. If you are paid per job, you're more likely to be an independent contractor. And if you're being paid a salary, regardless of how much work you do, then you are more likely to be an employee. So say that. And if the scenario doesn't say, you may have to speculate. You may have to say if they are paid per job, they are more likely to be an independent contractor. And if they're paid a salary, they're more likely to be an employee. So thinking about the second part of the Ready Mixed Concrete test, control, if you are subject to a higher level of control, you're more likely to be an employee than an independent contractor. Again, if there's nothing in the scenario, you may need to speculate. But in the one we looked at just now, it said that someone had been sent by Index Services, and that suggests that they had a level of control. The last thing is to think about all the other factors. So if there's a uniform provided or mutuality of obligation, you're more likely to be an employee. If the employer pays tax and national insurance, you're more likely to be an employee and not an independent contractor. If you're an independent contractor or self-employed person, you would be responsible for your own tax and national insurance. Mutuality of obligation just means that there's an obligation on the employer to provide work and an obligation on the employee to do the work. And that is not present when you have an independent contractor. That's something that's relevant for employee-employer relationships. It's worth noting that the law has been extended over recent years to not just cover strictly employees, but also those in relationships akin to employment. Akin just means similar to. And these requirements were set out in the Catholic Child Welfare Society case. And it covers people like priests, foster carers and football coaches. But there do still remain some true independent contractors who are genuinely self-employed and provide services to others not as an employee. For example, the doctor in various claimants and Barclays was found to be an independent contractor because he was paid per medical he carried out and could refuse to work. And this is seen in other situations, for example, electricians who have a number of customers, is not employed by any of them and remain a self-employed person. So once you have decided whether someone is an employee, you move on to the sufficiently close connection test. You should do this whether or not you think that the person might be an independent contractor, just so you make sure that you get all of the marks available for vicarious liability. So the sufficiently close connection test originally came from a case called Lister, and it was confirmed in Morrison's and various claimants. It asks, is there a sufficiently close connection between the field of activities and the wrongful conduct to make the employer liable under the principle of social justice? This means that there's going to be liability even if the employee is misusing their position, if they're ignoring specific instructions, or even if they are committing a crime or acting criminally. As long as you can show that there is a sufficiently close connection between their job and the wrongful conduct, that it would be just that the employer would be liable, then there will be vicarious liability. The only time that there would be no liability and no connection is where the employee is engaged in a completely independent venture, what is called in the old law a frolic of their own. So it's worth bearing in mind that there, more often than not, there is going to be vicarious liability. So let's think about how you would apply the close connection test. And both of the leading cases involve the supermarket chain Morrison's. So the first thing you need to do is to identify the field of activities, the job that that employee was actually doing, and then think, is there a close connection between their job and what they did for the tort, the negligent misstatement, whatever it was, to make it just that the employer should be vicariously liable. And it's helpful here to consider, is this case more like Mohammed and Morrison's, where Morrison's were found to be vicariously liable for an employee who hit a customer at a petrol station because he was furthering his employer's business, he was dealing with a customer, even though the way he did it was misguided? Or is it more like Morrison's and various claimants, where Morrison's were found not to be vicariously liable, where an employee leaked the personal data of around 100,000 employees and was found to be not furthering the employer's business, but they were engaging in a personal vendetta against Morrison's. And this is sometimes called an independent venture. So those are two very useful cases to think about when you're considering, is there a close connection? It's then very useful to go on to consider the traditional cases. So if you've decided that there is a sufficiently close connection, you should be trying to use a case from the traditional cases to back that up so that you agree with your conclusion as to whether there is vicarious liability. So these old cases sometimes refer to the course of employment instead of sufficiently close connection, but this is effectively what has become sufficiently close connection. And you need to look at these cases considering whether they are in the course of employment or on a frolic of their own to see if you can link one of them back to the scenario. So here the employer is liable for work that's authorised but carried out in an unauthorised way. And these cases are quite old. They're from 1862, 1942 and 1900. And several of them involve driving a horse-drawn bus. So in Limpus, the employee was driving the horse-drawn bus, and that was what he was employed to do, and he was authorised to do it. But he had been told not to race the bus. So when he did race the bus and caused an accident, he was still doing his work, but in an unauthorised way. And this meant the employer was vicariously liable, because you are liable even if the employee is doing the work in an unauthorised way. The second time the employer will be liable is where the employee is carrying out their job but doing it in a negligent way. And in the Century Insurance case, a petrol tanker driver negligently set fire to petrol at a petrol station, and the employer was found to be vicariously liable because they were doing their job, transferring the petrol from the tanker, but to smoke, which is what they were doing, was negligent, and the employer was found to be liable for that. An employer is only not liable if the employee is on a frolic of their own, which is like the independent venture we were just thinking about, the personal vendetta in Morrison's and various claimants. And the case of Beard is another case about a horse-drawn cart where the employee's job was a bus conductor checking tickets, but he actually went and drove the bus and caused an accident. And it was found that he was on a frolic of his own because this was outside the course of his employment. And so the employer was not vicariously liable. So my top tip would be, even if the employee is told not to do something, either orally or it's in their contract that they shouldn't do something, the employer will still be vicariously liable if the employee is in the course of employment or there is a sufficiently close connection in the modern terminology. So this is the scenario question from the 2020 AQA A-level exam. And so you might just want to pause to have a look at that. So to answer this question, there are three parts. You would need to do negligent misstatement, which you would do first, as it is the tort, and then vicarious liability second, as it doesn't make any sense to start with vicarious liability because there's nothing to be liable for unless you have proved the tort first. And lastly, there are the 7-mark part about the public policy reasons why we don't allow claims for pure economic loss, which comes from the law and society part of the exam. So in terms of vicarious liability, User Art Limited might be vicariously liable for Tina's tort if it can be proved that Tina was an employee and there was a sufficiently close connection between Tina's field of activities and the wrongful conduct. So you would have to go through the ready-mix concrete 3-part test for whether she was an employee and then consider whether there was a sufficiently close connection by identifying her field of activities. So the most common mistake in this scenario is to say that she has been told only to value paintings and she actually goes ahead and values a vase, and that means that User Art are not liable. That is not the case. If she's an employee with a sufficiently close connection between her field of activities and the wrongful act, they will be liable. And arguably here, her field of activities is valuing. It's valuation work, and that is what she was doing. So there is a sufficiently close connection between valuing and valuing a vase that it would be just to make the employer liable. It would accord with social justice. So she is furthering her employer's business, but in a misguided way, which is more like Morrison's and Mohammed than Morrison's and various claimants. So thinking about the traditional cases, that's supported by a case like Limpus, where the bus driver was forbidden to race the bus. And when he did race it, he was within the course of employment as he was doing an authorised act, but in an unauthorised way. And that's the same as here. Tina is doing an authorised act, valuing, but she's doing it in an unauthorised way. So the traditional case also supports the argument that User Art Limited here would be vicariously liable. So I hope that's been a useful summary of the law on vicarious liability. Thanks very much.